Hi, I'm Tom Marks with the Marks Law Firm in Orlando, Florida, and welcome to the Healthy Family Law Attorney. So today we have an expert in real estate law that's going to give us some pointers on some issues that family law clients run into. So remember, my purpose is because I believe your family matters. I want to provide hope and help your family to successfully navigate the family law process in a healthy way. And today, Scott Baker is going to help us do that. So Scott is a partner over at Zimmerman, Kaiser, and Sutcliffe. He's an experienced real estate, land use, and business lawyer. Scott is board certified as an expert in real estate law. So board certification basically means the Florida bar will give you that expert kind of designation of board certification if you have a certain amount of experience and qualifications and you take a really hard test and pass it. So that's what Scott has done. Scott loves to counsel his clients on strategies to avoid and resolve real estate and business disputes. And he's litigated cases throughout Florida. So let's welcome Scott. How are you?
Hey, Tom. I'm doing well. Thank you for having me.
Well, great. So today you're going to help our viewers, family law clients that are interested in some real estate questions. So first is husbands and wives, when they're married and they own real estate together, it's called owning it jointly by the entireties, right?
It's called a tenancy by the entireties.
Okay. So tell us, what are the benefits of that, first of all?
Sure, Tom. There's two main benefits. One is it's a great asset protection tool. And by that, I mean, if a creditor has a judgment against one of the spouses, the judgment will not attach to the real estate that the husband and wife own together. That's a big one during our lifetime. And then when one of the spouses passes away, the remaining spouse automatically gets title to the home. There's nothing that spouse has to do. They just at most have to record a death certificate for their deceased spouse. And there's no transfer, no probate, no court involvement. It's a very seamless and instant process.
Right. So now let's talk about what happens in a divorce situation where the husband and wife, now there's a divorce. So it automatically becomes a tenant in common, right?
That's right. The entry of a divorce final judgment automatically breaks the tenancy by the entireties. It breaks it into two pieces, and we call those pieces, that way of ownership, a tenancy in common. So each person is a 50% owner of the whole property. And that can cause some problems at the end of a divorce when the property hasn't been dealt with properly and one spouse has moved out, but still has the right to occupy the entire home after the judgment. And if the home is not properly transferred to someone else, you have an awkward situation where two people who have just decided to not live together or spend their lives together anymore can both occupy the home legally.
Okay, so we're going to talk about some potential solutions for that,
Right.
or ways to avoid that. But before we do, I know you're a member of the National Association of Divorce Professionals, and I know that we have mortgage brokers and realtors and title agent and so forth in our group. Tell us how you work with them to help family law clients or in a real estate situation.
Well, sure. I would reach out to those professionals to provide services I can't provide, simply put. I've had recent experience with them with a mortgage broker that was very positive, and that person worked very quickly and had a lot of passion for getting the deal done and made it happen with a minimum of fuss. And I've also been recently appointed by a court in Florida to it's called a special magistrate, and the judge ordered me to sell some real estate. So I went to NADP and hired a realtor out of NADP, our group here in Orlando. And she has been excellent at marketing the property. And actually, she got the property under contract in 2 days. And so I'm getting to sell the property and make the court happy and do my job as a special magistrate with her help.
Well, I'm thrilled to hear that, because that's been my experience with the other professionals in the group, especially right now with the real estate market. The realtors are getting houses under contract very quickly, and oftentimes for above the asking price.
Right.
Okay, so let's talk about some solutions. One way to transfer the property from one spouse to another during the divorce, so I guess it could be done afterwards, is by a quitclaim deed. So tell us, what is a quitclaim deed?
Yeah, a quitclaim deed is a way of transferring real estate that doesn't have any of the typical warranties in it. That doesn't mean there's something wrong with it. It's just an easy, simple way to transfer one spouse's interest over to another spouse's interest. And it's a deed that, and the tricky thing is when you're married, so if you do it before you divorce, both spouses have to sign it because of our constitutional restrictions on, spouses selling property. There's, if I could back up 1 second, in Florida, we don't let a spouse sell his or her property out from the other one. You can't go out there and sell property if you're married and you own the house as a married couple without the other spouse knowing about it and joining in on the deed. So if you're ready to divorce and you worked with your family lawyer, you need to sign that quitclaim deed. Both parties sign it. You can sign it separately. You don't have to be in the same room and sign it, but you each have to sign it at some point. And then you record that deed, and that's a perfectly valid transfer of the property to the other spouse. Now, that doesn't deal with the mortgage. That doesn't deal with the promissory note that you may have signed when you bought the property. So you may be doing this in conjunction with a refinancing of the home, in which the other spouse, the one who's leaving, their name comes off the mortgage and off the promissory note. And maybe they even get some equity out of it and walk away with some equity.
Right. And that's a really good point. So clients need to know that just because they sign a quitclaim deed and convey their interest in the home to their spouse, it in no way controls the lender or the obligation to the lender. So even though you've quitclaimed and you have no interest in the title of the house, I guess, the lender could still come after you for payment of the mortgage if your spouse who got the house stops paying the mortgage. So that's a really good point,
Yeah.
Scott.
It happens all the time that people do a quitclaim deed, they don't deal with the mortgage, and they wind up with a process server at their front door, and they learn that they've been sued on that mortgage debt. And the other spouse says, "Oh, I'll take care of it. Don't worry. I'll make those payments for you."
Right.
That's great. But what happens when they can't make those payments anymore?
Right. So that's why I always make sure in the marital settlement agreement that there's going to be a refinance, and that I put some protections in there that the refinance has to be finalized within a certain number of days. If it's not, then the house has to be sold. Oftentimes, I actually have the quitclaim deed held until the closing at the refi, so that my client is protected. But
Right.
here's another issue, Scott. Let's say the marital settlement agreement says that your one spouse is supposed to sign a quitclaim deed, and then it's reduced to the final judgment, which incorporates those requirements in the settlement agreement, and they get divorced, and then somehow that quitclaim deed never gets executed. Nobody follows through on it. What happens then?
Well, basically, one of two things can happen. If the final judgment of the divorce doesn't have certain magic words in it, it's not considered a conveyance. In other words, it's just a divorce final judgment, and it doesn't do anything to settle the property ownership. And so years can go by, and I've had cases where decades have gone by, and the property was never truly or properly transferred away from the spouse who left. The other way this can go is there's magic language put in the final divorce judgment, and it's considered a conveyance. So all you have to do is get a certified copy of that judgment from the courthouse and record it, and you're done. Everything's fine.
So good practice pointer here. What I do in those cases is, if I don't have the quit claim deed already executed and ready to go, then I put that, what you call magic language, in the final judgment in case we can't get the other spouse to sign the quit claim deed. The final judgment takes care of it, right?
Right. That's exactly right. So that helps us deal with the person who's starting a new life and moving away and doesn't want to have anything to do with Florida or their former spouse ever again.
Perfect. So, okay. I think that's really helpful to our viewers. These are some things to really consider with regard to a quitclaim deed and tenancy by in common and so forth. So Scott, of course, this is the healthy family law attorney. So give us your healthy tip for today.
Okay, I'm going to give you the thing that came to my mind immediately when you mentioned healthy family law attorney that has helped me over the last year and a half. And ready for this, Tom? You're going to be surprised. It's called myofascial release massage. And it's a special kind of massage that deals with this connective tissue we have all over our body that can get tight and brittle and old and prevent us from moving the way we're supposed to move. And it's really helped me with chronic pain over the last 2 years. So it's called myofascial release, and chiropractors can do it, massage therapists can do it, and it's pretty cool.
Wow, that's great.
Yeah.
You know, it's so interesting to me, Scott. I've done probably 25 interviews now. Everybody comes up with a healthy tip, and no two tips have been the same. So that's awesome. Thanks for sharing that.
You're welcome.
So if you've enjoyed this video, please hit that like button and subscribe to the channel. Of course, hit the bell icon so you don't miss any future videos. We've got new legal topic videos coming out every Wednesday and interviews like this one today every Friday. So thank you for being part of the channel. Leave a comment if you have any questions or you'd like to hear any particular topic in the future. I would be happy to do that. Thanks so much for being on the channel today, and we'll see you next time.